Good afternoon. We should probably get started since I know it's going to be a thought-provoking talk, and there'll be ideally some time for questions and answers afterwards. I'm Lawrence Sawson, and on behalf of Osgoode Hall Law School, I'm very pleased to welcome you to the kickoff of this year's Genest Fellows program. And I'll get to introducing Ngaire in a moment, but let me start by, for those of you who don't know, telling you something about how this came to be. The Pierre Genest Fellows Program was created in 1989 here at Osgoode, and each year it brings a slate of internationally recognized scholars to the law school, not just to share their knowledge and insights in wonderful talks with above-average food, as on occasions like this, but also to engage in lots of discussions with graduate students, with JD students, with colleagues, and to be contributing to the academic and intellectual life of Osgoode on compelling, pressing issues of contemporary law and policy, and that's certainly the case for today's talk. For those of you who don't know the story of Pierre Genest, he was a graduate of the school, an extremely accomplished counsel, renowned throughout the legal community, former treasurer of the Law Society of Upper Canada, and this program created in his honor, I think, represents the best of that bridge between issues of importance to the legal community and the academic community, and again, as we said, the broader policy community. So for more information on the sessions, I'm reliably told the research office website has all the details of the upcoming talks and, of course, some of the luminaries who've joined us in the past, so I encourage you to check that out at your earliest convenience. And that brings me to Professor Ngaire Naffine, who is joining us today and for the last number of days from Australia, where she is the Bonithan, close enough, professor of law at the University of Adelaide, and her research interests, which those of you who've gone to one of the earlier sessions will know span broad areas, but focus primarily on criminal law, criminology, jurisprudence, feminist legal theory, health and medical law, and of course the linkages between those topics. Her most recent book, and I said to her, represented the old academic trick of aiming really low and modest, and then everyone says it's about much more than you said it was, is the book Law's Meaning of Life, Philosophy, Religion, Darwin, and the Legal Person. So it's an extraordinary piece of work and looks at the impact of philosophy, religion, and evolutionary biology on law and the construction of the legal person. She's had a number of other visiting gigs, ranging from the Hastings Bioethics Center in New York to Cleveland Marshall College of Law in Cleveland, and has also spent time in Florence, but you never know if it's for the scenery or the scholarship. So we know if you're coming here, it's not for the rolling hills of Downsview, it's to share your ideas and your thoughts with us. And today, the title of the lecture is The Gorilla in Our Midst, Inattentional, Blindness to Sanctioned, Brutality in Criminal Law. I didn't bother to memorize the acronym, but you'll know it when you see it. And this is not the Sigourney Weaver version of Gorillas in the Mist. This is a much more thoughtful and, as I said, thought-provoking set of ideas. So please, without any further delay, join me in welcoming Ngaire, and look forward to the questions that come afterwards. Welcome.
Thank you very much for coming. It's a great pleasure to see you, I hope. Firstly, some thanks to the Genest Global Faculty Fund. I'm very grateful. To Professor Ben Berger and his colloquium on law, religion, and social thought, and to Professor Sonia Lawrence and her Institute for Feminist Legal Studies. Right, straight into it. I have a lot to cover. My paper is about the centre of British culture in its basic warp and woof, and I wish to consider the heart and the heart of the British Empire, ordinary, intimate, private, married life, which some of you may know about and some of you may be avoiding. And this is the place to which the British scholar, the judge, and the lawmaker goes home at night. And I'm interested in the manner in which it is regulated by public criminal law. I wish to consider this institution of really British marriage, which has been exported to here, no doubt, from the point of view of the criminal lawyer, which is an unusual thing to do. What do criminal lawyers think of the criminal law of marriage? If they think of it at all. Indeed, my principal argument is that they have tended not to apply their mind to marriage, the criminal law of it, and they have not applied it to their fundamental principles. My argument is that there is a remarkably large blind spot, and it's having its effect on criminal law as a discipline, as a body of knowledge, its scholarship. So, the criminal jurisprudence of marriage is a topic not just close to the home of the criminal law scholar, but it is home. It's therefore an inquiry into the affective and the familiar and the intimate, but from the point of view of a criminal lawyer, where we don't tend to go. I'm looking at the criminal law of married life, and more particularly into the thinking of some of the more distinguished criminal jurists and intellectuals. What do they think about this institution? What do they think criminal law is doing here? What do they think criminal law is doing when it is confronted with some of the nastiest forms of sexual violence, where the worst things occur? Assault, rape, and murder, to put it pithily. Why is this a tricky topic? And I think it is a tricky topic. And I want to invoke the great Irish social historian Oliver McDonagh, who reminded us that Robert Louis Stevenson defined marriage as a sort of friendship recognised by the police. And I think Eric Hobsbawm has just died. So for the social historians, I commemorate his life. So Robert Louis Stevenson thus drolly brought into relief the serious oddness and difficulty of combining the intimate and the criminal, especially when the criminal behaviour is about as bad as it gets: violent, coerced sex, rape. Here we're dealing with a zone of criminal regulation of mixed significance. It's a place of the greatest love and the place of the greatest horror. And my main suggestion is that criminal legal scholars and jurists and judges and lawmakers have themselves encountered serious intellectual and moral difficulty with this combination of ideas, with the criminal and the intimate. There are problems of cognitive dissonance, of category confusion, which may in turn lead to denial or to willful blindness, and to the sanctioning of laws which undermine the most fundamental liberal commitments to our personal safety. Criminal lawyers are deeply interested in the problem of criminalisation. Are you familiar with that word? Criminalisation. It's a ghastly word, but turning something into the province of criminal law. The problem of setting proper limits to state power is critical, particularly in this day and age, and where to set the proper boundaries of criminal law. And it could be said that the criminal regulation of marriage is a boundary problem. It's a fundamental boundary problem. However, the attention of scholars has been directed at the outer edges of criminal law, such as the unprincipled regulation of antisocial street behaviour. I'm thinking of the London riots, which I was in London for, though I only saw them, that didn't happen to me. And I think criminal lawyers are particularly preoccupied with terrorism, terrorist laws, and whether criminal law is coming in far too early, anticipating terrorism. They're much less concerned with the interior wall, the boundary, the family home wall. Adding to this intellectual tension and confusion is the mixed large-scale and small-scale nature of this problem. It is of great international significance. It's a problem on a very large scale, and it concerns one of Britain's major exports to the colonies, to the common law world. The form of the family, its civil and its criminal regulation, and its implantation into Australia, into Canada, into New Zealand. So it does not look outwards, this problem, it looks inwards. We're looking at the exportation of a very major institution, and yet we're looking inwards to our own homes. Outwards, it looks like a major significant cultural feat to push it out into the colonies, but it's also a small environment, the small and the domestic. And it's not exotic and primitive. We're not looking outwards to other foreign countries. We're looking at ourselves, at the intimate, at our dirty linen, which we might not want to air and we may not want to talk about, to the point that the criminal law of marriage is almost an oxymoron. Not a topic you will find in criminal textbooks. So, marriage is about love and intimacy, but ordinary married life also is a place of horror, of appalling abuse. And in my last talk, I mentioned John Stuart Mill. His wonderful book on the subjection of women, which should be read by all literate and right-minding people, and you'll be stirred yet again by this wonderful writer, who had a fine marriage, I believe, and a good wife. He said, writing of the British marriage, even the commonest men reserve the violent, the sulky, the undisguised, selfish side of their character for those who have no power to withstand it. The relation of superiors to dependents is the nursery of their vices of character, which, wherever else they exist, are an overflowing from that source. Mill was writing in the 19th century, and his words are sharply fresh for us. And in fact, it's hard to find such moral urgency in current criminal law writing, in textbooks and in the scholarly journals. There has been a sustained legal reluctance to look at this problem, and there's even been a legal reluctance to criminalise it, which taints people like myself, criminal lawyers, who have often spoken up to keep criminal law out of this zone. It's provoked little intellectual interest. It's not regarded, curiously, as a sexy topic. It's hard to find that, and I'm particularly familiar with the English Oxford, Cambridge jurists and what they're writing about. And this is not a topic which is close to their heart, and I don't think they find it intellectually interesting or challenging. And worse still, not the current generation, but previous generations of criminal law scholars have famously spoken up and said, really, this is not a zone for criminal law at all, which is very problematic. But I suggest being close up to a topic makes it difficult to see, which is why I have this preposterous title of The Gorilla in Our Midst. And in fact, the day that I came here, Jane Goodall was speaking at Loblaws. I didn't see her. She was launching coffee. And I thought, there's a sign here. Jane Goodall knows I've come. But my argument is that seeing the ordinary is curiously difficult when it's all around you and it is life. I'm not suggesting that all marriages are violence, but an insensitivity to the marriage environment as a suitable one for criminal regulation is odd. And in fact, the acceptance of the immunity from rape prosecution of all husbands has not been a cause of major concern to criminal law scholars. So they've really gone home to a criminal law-free zone. They go off to work to do with criminal law and come home to a criminal law-free zone. So what is going on? And this is where I invoke note vision. No, I don't. I hope it will come back. I'm going to talk about the Harvard experiment conducted by Simons and Chabris in 1999.
This is a test of selective attention. Count how many times the players wearing white pass the basketball. How many passes did you count? The correct answer is 15 passes. But did you see the gorilla?
I did see the gorilla because I'd warned you about the gorilla. But honestly, people do not see the gorilla. When they're not told that that gorilla is going to walk through, amazingly, I think it's the figures are over 90% of people do not see the gorilla. This was a neat experiment by Simons and Chabris, which was on what they called it inattentional blindness. The point was to show that if your attention is carefully trained on one thing, you will not see the most obvious thing occurring simultaneously. And that's a simple idea which I'm employing in this paper. And I actually think it, as a psychological and an intellectual matter, it is true. And it actually fits in with the work of Thomas Kuhn in The Structure of Scientific Revolutions and Thomas Nagel in The View from Nowhere. This idea of how we see things and what we can't see, what gets excluded and simply not seen at all. Another work I want to refer to is a fabulous book called The Master and His Emissary, which is on left and right brain thinking by a marvellous psychiatrist and philosopher, Ian McGilchrist. He invoked this experiment in his book, and he said that we see, at least consciously, only what we are attending to in a focused way, such that our attention is guided by our expectations of what we are going to see. In an important sense, we experience what we know already. And we do not experience what we do not expect to see. His words, our incapacity to see the most apparent, obvious features of the world around us, if they do not fit the template we are already working with, is so entrenched that it is hard to know how we arrive at anything new, which is a very interesting intellectual and psychological problem, and a problem for all of us in universities too, trying to see beyond the existing ways we are already looking at the world. And I've chosen the gorilla experiment for some pretty obvious reasons. It's doing double work. One is on the selectivity of perception, and the fact that also it's really quite a brutal thing that we're looking at. We've got a gorilla in a certain suit, walking through a very civilised whitey's basketball game, and all we can see is the basketball game. And my gorilla is state-sanctioned violence in the heart of marriage and the failure to see it. The criminal law has accommodated domestic brutes, and it did so until late in the 20th century, despite what John Stuart Mill said a hang of a lot earlier. So the law has in fact operated with a fiction that it will attend to assaults when they occur, wherever they occur, but when the assaults morph into rape, they will become legally invisible within the home, and the wife will be disabled from complaining. It is a form of deeming. It's almost like the doctrine of double effect. X will be true, but Y will not be true. It is a formal legal fiction, which my modestly named book is about, on legal personhood, about deemings and fictions. Now, I'm going to present two case studies as demonstrations of this inattentional blindness in this area of wife rape. The first one comes from England, 1975, when the marital immunity was still securely in place. And the next one comes from 2 months ago in Australia, a major landmark case. And I have spoken about the latter case in my colloquium with Professor Berger. So the first case is DPP and Morgan. May I ask whether there are any criminal law scholars here and whether you've done this case? DPP and Morgan? You do it? And it's important, isn't it? Still, here in Canada? I think so. I'll tell you why it is important and ignore the professor over here, whatever he says. DPP and Morgan. This is my first case of inattentional blindness, and I can tell you that this is a case which has been tremendously important to Anglo-Australian legal scholarship. DPP and Morgan. In 1975, the case came before the courts. I'll say that the incident occurred in 1975. Mr. Morgan was in the army. He was walking around the English town of Manchester. He was with a couple of army mates, and he was looking for prostitutes. They were unsuccessful in finding prostitutes, and so he said to his mates, "Come home with me and have intercourse with my wife. She enjoys," and I think this is a quote, "kinky sex, and she will struggle, she will fight, she will say she does not want it, but that will only be telling you that she does want it." They went home to the house of Mr. Morgan, and Daphne Morgan was there home with her young son. The young son was put into another room, and she was held down and serially raped by the friends and by Mr. Morgan himself. In this case, there was hardly a murmur from the highest court, because this went up to the House of Lords, on the fact that Mr. Morgan was immune from prosecution. In this case, he was only charged with aiding and abetting. He could not be a principal offender because of the immunity. And the court made, I think there was one paragraph in the entire case which said, well, the prosecution saw fit not to prosecute Mr. Morgan as a principal because of the immunity. Blah, blah, end of story. Now, this case becomes intellectually very important for criminal law, but not because of the immunity. That part is forgotten and is neglected, and it's something which has bothered me for many years as a criminal law scholar. It came to stand for the importance of the subjective mental element in rape. The House of Lords proclaimed, and this was the rule that came out of the case, that if the accused believed that he had the victim's consent, no matter how unreasonable was that belief, he could not be guilty. There was no rape, he could not be criminally responsible. He had to have a subjective appreciation of non-consent. And this rule really garnered a lot of support among criminal law scholars as a general rule which applies to all core serious offences. It is still generally thought that if the accused does not understand the significance of what they're doing subjectively, they are not criminally responsible. In a sense, Morgan became the litmus test of mens rea, of subjective mens rea. It said that without subjective appreciation, you did not fulfil the proper conditions of criminal responsibility. Now, on the facts, no one believed Mr. Morgan's friends. They said it was preposterous. So the argument did not succeed on the facts, but the rule that came out of it very clearly and stayed put for decades was of the importance of subjective appreciation of mens rea, of subjectivism. And the immunity was passed over very lightly by the court. This curious neglect and toleration of wife rape as a topic persisted in the subsequent analysis of this case. There was great attention to the case. In Australia and in England, certainly, it was difficult to get away from this case. and it was the centre of the debates about subjectivism. And many orthodox lawyers, and in some ways I can understand the argument, said if you do not have subjective mens rea, you really do not have a criminal person, someone with criminal intent. So the case of Morgan was both intently studied, but selectively so. It also came to stand for a case on rape, and rape being a core wrong and a standard wrong. It was repeatedly said that rape and murder were crimes that were so profoundly serious they had to be criminalised in the right way, which was why subjective mental element was so important. It was very important to get these two crimes right. Now, the one person who knew absolutely in that case that Mrs. Morgan was not consenting, that she was fighting tooth and nail because she really didn't want it, was Mr. Morgan, but he was home and hosed on that, to use a colloquialism. He could only be charged with aiding and abetting, and he had the complete licence of law. Right up to this case in Australia, which I'm going to speak about in a minute, this case of Morgan gets referred to, but not for this critical missing element. So we have a landmark rape decision, very much analysed, but there's a central piece of the intellectual and moral problem missing and not alluded to. The second case from South Australia, hot off the press. In fact, it hasn't gone to trial yet. And it may not, because of the antiquity of the alleged offence. In May this year, the Australian High Court of Australia, which is our highest court, in the case of PGA, the case of Mr. P, was asked to pronounce on the legality of rape in marriage and whether it was a crime known to law in 1963. The alleged rape was 1963, and the accused is now in his 80s. The second Mrs. P came along to the duty solicitor's office saying, to sort this out, it's not an offence. I mean, it's just ridiculous. And the duty solicitor said, oh, it is a serious crime if they're going to proceed with it. And astonishingly, the prosecution office did proceed with it. Just to show what students can do, it was a former honours student of mine who has pushed this matter up to the High Court and won, which is astonishing. Not that that much has been made of this decision, yet again, despite the dramatic change of law that it represents. To explain this case briefly, in 1976, South Australia was the first jurisdiction in the common law world to criminalise wife rape. The first jurisdiction from my enlightened little town of Adelaide. Aggravated wife rape was turned into a crime in 1976. Then the rest of the world began to follow suit. In the 1980s, the different South Australian jurisdictions, we have different criminal law jurisdictions, by statute criminalised rape, and Canada did it in 1983. It already had it in its statute that it was perfectly lawful. So in 1983, it was beginning to follow the world trend and to criminalise this matter. The Australian High Court addressed it at common law in 1991 and said the common law around Australia does not recognise this immunity anymore. England did it in 1991. Scotland did it in 1989. So these are dramatic changes to the potential population of rapists which have occurred late in the 20th century. The well-accepted principle was amazingly that given by Sir Matthew Hale, who's been regarded as the god of scholars, and he still is treated as a great distinguished jurist. He died in 1676, and his thoughts were published 60 years later, in 1736. In 1736, he said that a wife would be presumed to consent at the point of marriage. He also said that rape was a crime easy to allege and difficult to refute, which had no statistical backing, but has been said up to the late 20th century. So Hale has been trotted out as if he wrote it in the Oxford Journal of Legal Studies last week. These are not even common law writings, they're extrajudicial writings, the pleas of the Crown. So, was Matthew Hale still good law in 1963, was the question for South Australia. The South Australian Court of Criminal Appeal, our highest state court, said yes. With my brilliant law student that was arguing, they said it was a crime in 1963. Totally counterintuitive, no one would have expected that. It was then pushed up to the High Court by the lawyer for Mr. P. And the High Court, and I spoke about this in my last talk, was pretty well inflamed by the arguments of the defence that it couldn't have possibly been a crime in Australia then because we were such a backward nation. We had the White Australia policy. We fired women in the public service as soon as they got married. We were pre-Enlightenment. And then Mr. Bennett said, and so was the rest of the common law world. So there. Now, not surprisingly, the High Court was deeply offended by this. No face-saving possibility was given to the High Court. They said, rubbish! We were giving women the vote before England. England may have been unenlightened, but we were enlightened. In fact, we were so enlightened that we didn't even receive this rule. By the early 1930s, wife was a crime known to law in Australia, which is utterly implausible, but is now the legal truth of it, because the High Court has said so. Now, what's striking about this case, and remember I'm talking about inattentional blindness, was the willingness of the majority to be persuaded by the prosecution argument that wife rape was a crime known to law, even though it was never ever used. No one prosecuted it. It was utterly neglected. For all practical purposes, it did not exist. It was treated like something of a sleeping tiger. It was there in the background. It wasn't being used. No one had turned their mind to it. But because no one turned their mind to it, none of the judges had said it didn't exist. So it did exist. And this was literally the argument. The QC for the prosecution said, our submission is, despite many a trial judge accepting that Sir Matthew Hale stated what the law was, no one ever turned their mind to it, to what the actual common law was. The judges hadn't considered it, it wasn't used, it was neglected, but it did exist. A heroic argument which I think, given the sheer irritation, the provocation to the High Court, succeeded. It probably shouldn't have succeeded. It's not a good case. The High Court said the immunity was an ancient and perhaps partially forgotten principle. The tooth of time had gradually eaten away at this ancient precedent. It had become obsolete and inoperative, which is effectively a declaratory theory of law. They were declaring the true nature of the law. Given how times had changed, this had also happened to the law. It had disappeared. The inattentional blindness of the High Court was its non-enforcement, the non-use of this crime, of which it made absolutely nothing. It turns a blind eye to decades of state inaction about this crime. It points out that there's absolutely no case law. What does that mean? No prosecutions. Doesn't refer to them. Nor is it the slightest bit concerned that there's going to be a great backlog of complaints as the wives of Australia now go back to the 1930s, trawling through their abuses by their husbands and bring them before the court. It doesn't think of that at all. And in the back of its mind, it knows full well that wives are not going to be coming forward in their droves and complaining of rape. The dissenting judges, of which there were two, said this was ridiculous. No one prosecuted it because it was fully accepted that it was not a crime. Non-prosecution was because the crime was not there. And really, this is the more plausible argument, and this will generate lots of writing, and that's what people are going to start saying. Another dissenting judge, a woman, also pointed to the distinguished line of criminal law scholarship supporting the rule. So she called in aid criminal law scholars. And she didn't say they were rubbish. She said they were terrific. She in particular talked about Sir Matthew Hale, we're talking the 17th century here, and his rule of the presumption of consent. The omission in her case, since I'm pushing through this idea of inattention, was Hale's role in witchcraft trials. Hale was responsible for at least 2 successful prosecutions of witches. He believed in witchcraft. This person, who's been used authoritatively until a few decades ago, gave a summing up to the jury which led to a conviction in half an hour and the hanging of 2 old ladies. And there's a very fine book on it if you want to read about it. So Hale, who was treated as an authoritative figure, also believed in witches. And this rather darker side of Hale not mentioned at all. On to other criminal law scholars and what they have had to say about wife rape. Hale was from the Dark Ages. I mean, some of them were believing in witches still. Witchcraft was dying out, happily. There were mixed opinions at the time that Hale was speaking and writing extrajudicially, so that there were split thoughts on whether witches really existed, but Hale was a supporter of them. So he really was a man from the Dark Ages, from a completely different paradigm. But the view that wife rape was unsuitable material for criminal law was stated over and over again by the top lawyers in Australia and England and by the major government inquiries. In the 1950s, Norval Morris, you may have heard of him. Have you heard of Norval Morris? Perhaps not. It's troubled. He said that there will, however, be some cases where the wife may consistently repel her husband's advances. If the wife is adamant in her refusal, the husband must choose between letting his wife's will prevail, thus wrecking the marriage, and acting without her consent. It would be intolerable if he were to be conditioned in his course of action by the threat of criminal proceedings. Intolerable. 1960s, another very distinguished Australian criminal law scholar who's just died, Colin Howard, said, and again, these are criminal law scholars who are trying to influence the law, a husband should not walk in the shadow of the law of rape in trying to regulate his sexual relationships with his wife. If a marriage runs into difficulty, the criminal law should not give to either party to the marriage the power to visit more misery upon the other than is unavoidable in the nature of things. And the major inquiry into whether this law should change in England in the 1980s said, okay, violence occurs in marriage. It might drive couples apart. But a prosecution for rape might necessitate a complicated and unedifying investigation of the marital history, which you wouldn't want. Some of us consider that the criminal law should keep out of marital relationships, except where injury arises, which again is a very odd idea of rape as a non-injurious offence. And Glanville Williams, who was the big scholar in England, was saying precisely the same things. And in 1991, when Britain saw fit to get rid of this immunity, he was supporting it, saying it's too severe a crime to be employed within a marriage. Now, these days, legal scholars would flinch at these statements. And I am, in some ways, presenting you with an historical story of criminal law and how criminal lawyers have examined violence and personal safety and bodily integrity. But I want to take it right up to the present and talk about what I think it's been doing to the quality of their scholarship, how persuasive they are, whether they're doing good work. What effect does this inattention do to their own writing and their own thoughts? At the time that the immunity was abandoned, there wasn't much made of it. So in 1991 in England, for example, there wasn't a great hoo-ha. My goodness, now we must rethink this offence. We must now rethink the offences against the person the central core offences of rape has radically changed. Not at all. The leading scholars from Oxford and Cambridge said there was an anomaly corrected. It was simply an anomaly. A shift to the legal furniture, I'm paraphrasing. It was a correctable change, and it was part of modernisation of criminal law. No felt need to go back to the drawing board and reconsider the offences against the person. But I think criminal legal scholarship has been seriously skewed by the unthinking practice of beginning intellectual inquiry once a scholar or the judge, and I'm conscious that I'm sliding between common law reasoning and judges and government inquiries and scholars, but they're each of them doing the same thing. They each think that inquiry begins once the judge or the scholar leaves home. The work begins outside the home. By leaving the criminal law of marriage uninspected, in fact, not even having a category of criminal law of marriage, this important negative feature of criminal law has been omitted from the most basic investigation into crime and criminal law without thought and without intellectual justification. And this has had some odd effects, both on the characterisation of criminal behaviour, and here I speak as a former criminologist, and it's had some odd effects on the characterisation of criminal law, of criminal jurisprudence. In terms of the characterisation of criminal behaviour, there persists a great insensitivity in the scholarship in criminal law on the very different patterns of offending and victimisation of men and women. Violent crime, and especially violent sex crime, are profoundly gendered. The two sexes have yet to feature as two distinct objects of legal inquiry in the criminological literature or the criminal law scholarship with which I'm now more familiar. Men and women, however, behave very differently. To state the obvious, men are significantly more violent, which does not mean that women are not violent. It does not mean that women never beat up their husbands. They do, but we're looking at the majority and the minority problems. And indeed, the anticipation of male sexual violence causes women to organise their lives in a certain way. And every woman in this room will do that. We will organise our lives because we're women, and what we do in the public will be influenced by who's walking down the street, what looks safe, and it'll often just be done like that in a flash intuitively. And Jennifer Nadelsky said recently in her fabulous book, Laws Relations, both young men and women grow up learning that male violence against women is to be expected, and she refers to men, she doesn't pull her punches, as the predators and women as their prey. Of course, not all men are like this, and not all women are victims. And I've got a very fine husband at home. So, in fact, I have total support. He's my John Stuart Mill, I must say. He sends me out to fight the good cause. Nor is there a sense in the criminal law literature that the public and private spheres of life are diametrically different for men and women in terms of their peace and security. For men, the public sphere is the primary place of danger, and for women, it's really the private sphere. And because women are taking precautionary measures in the public sphere, so if they're not going to the dangerous places, but the men are, they're less likely to be beaten up and attacked in public, much more likely to be beaten up, attacked, raped, or killed at home. So these spheres of behaviour are dramatically different for men and women. Yet, standard criminal law analysis still typically treats its subject matter as gender neutral. And even more curiously, it started using the female pronoun to stand in for men and women, as if this made criminological sense. So no doubt this new practice of referring to the offender as she is animated by a desire to be fair-minded and make up for past insensitivities to women. But it is seriously misleading in this context. It is a mode of affirmative action women could do without. And it drives me nuts every time I see it. Be warned, my comrades in criminal law. I mean, if you're going to use she, then you've got to consider, does it make sense at all in the literature? This gender blindness has been accentuated by a philosophical turn in criminal legal scholarship, especially in Britain. I'm not sure whether it's followed quite the same course here. And there has been a renewed search for the true essences of crime. John Gardner's associated with this, Anthony Duff, Victor Tadros, are searching for the true essence of crimes, for their intrinsic universal nature, as if they almost had Platonic forms. There's a search to capture the essence of rape and the essence of murder. And I think this very abstract theory tends to extract criminal law from its practical social settings and places it on another level of abstraction. So the chat's going on quite outside of the context of the actual behaviour. Not all the time, of course, but it is a strong tendency. It's referred to as legal moralism. There's also a modern tendency to treat these serious crimes as the clearest instances of true crime. You want to get to the essence of a crime. You want that crime to be a true crime. Rape and murder are treated as true crimes, as stigmatic crimes, as core crimes. Recently, Vinerian Professor of English Law at Oxford, Andrew Ashworth, said, "The operation of the criminal law requires little explanation in clear cases." And he then identifies intentional killing and rape as clear cases. Little justification. And yet the coverage of rape law and the potential population of offenders and victims has changed dramatically, for only recently all marriages were exempt. And now this is no trivial thing behaviourally, intellectually. It does call for explanation and for a rethinking of the basic theories of responsibility. The neglect of the marital immunity has arguably tainted the work of criminal lawyers in the two areas which account for much of their current legal scholarship. To explain, it's probably true to say that the two central problems of criminal law theory, as scholars have set and defined those problems, are the boundary problem, where to set the proper boundaries of criminal law, and then the proper conditions of responsibility. How do you hold someone appropriately and fairly responsible once you've decided that they are within the proper boundaries of criminal law? So what sort of behaviour should be made criminal, and then how should that behaviour be made criminal, is the essence of it. On the boundary problem, the attention of the leading scholars has been firmly directed at the outside boundary, and it's going on as we speak. There is a veritable industry. There are conferences. People are travelling the world, criminal law scholars, deciding whether antisocial behaviour orders, street rioting, should these come into the criminal law? Are we punishing people unfairly? Are they working class offences? What do we do with rioting? And are the legislative responses too harsh on rioters, because they do tend to be more anticipatory? So there's lots of stuff on rioting. There's another area of industry which, as I said, was the terrorism literature. How do you step in, and when do you step in when someone is thought to be a potential terrorist? Criminal lawyers have tended to group together and say the state is stepping in too early, is criminalising thought, not action. So this outside boundary problem of terrorists out there, people out on the streets, is producing an immense amount of scholarship. The inside boundary is being neglected, the inside boundary being the boundary wall of the home. And one can find some sensitive scholars saying, look, we're really not still that interested in domestic violence or in rape. And yet it is so important to the breadth of the material that they're looking at. Indeed, the division of crimes into core crimes and boundary crimes, a division which tends to be assumed in the work on criminalisation, becomes very problematic when one considers that rape has been both regarded as a clear core crime, not regarding justification or explanation because it's inherently wrong, and yet all husbands have been exempted from responsibility, which puts them outside the boundary of criminal law for a core crime. So I think it's a real category problem which needs addressing. So too, the analysis of the proper conditions of criminal responsibility. for the true crimes is seriously weakened when one considers that the human agents who have been considered fitting subjects of responsibility have only been a subset of the potential population, the exclusion of the husband. Once these excluded husbands are factored in, does responsibility operate in the same way? We don't know, because the question is not being asked. Does responsibility work in the same way? There's a huge literature on responsibility, on choice responsibility, on character responsibility, but the fact that the stuff that we're looking at has really changed its character is simply not being addressed. So the problem is of the utterly familiar. The objective and dispassionate analysis of the criminal law of marriage, which is what I'm calling for. I'm calling for good research, objective research, tough research, is rendered difficult by the full immersion of the analysts within the institution they are studying. I suggest that they experience the sort of intellectual problem encountered by sociologists of the family. It has been said of the latter, a book by Michael Anderson, one source of difficulty, and this is a description of the problem of sociologists of the family actually studying their subject matter. The paradox with which every sociologist has to contend is that he knows at the outset too much about what he's supposed to be studying. Normally, he has been and still is a fully participating member of a family unit of his own. He's been socialised from birth into certain beliefs about the family. He's internalised society's rules. Thus, he finds it difficult to stand back, view the family critically from without, and see beneath the manifest structures and functions of the system to the constraints which lie behind the traditional and normatively prescribed patterns. He knows so well. Absolutely immersed, so cannot see it. Further, because the student of the family is so deeply involved in the system, and because family values have been such strong, emotionally charged moral overtones, it's hard for him to view family behaviour in a value-free way. It's difficult doing good research in this area. So returning to the gorilla experiment, it can be said that, and I'm quoting McGilchrist again, we see at least consciously only what we are attending to in a focused way, so that our attention is guided by our expectations of what we're going to see. So in an important sense, we experience what we know already, and we don't experience what we don't expect to see. Quote, our incapacity to see the most apparently obvious features of the world around us, if they do not fit the template we are already working with, is so entrenched that it is hard to know, and here I repeat, it's hard to know how we can ever come to experience anything truly new. So this is a real perceptual and psychological and intellectual problem. And again, I would push you to look at Thomas Kuhn on Scientific Revolutions and Thomas Nagel, both wonderful books. So to finish, criminal lawyers have a great institutional investment in their current ways of seeing. If only they would sing more. I think they'd be happier chappies. Careers are built up on this. And Thomas Kuhn in the Structure of Scientific Revolution said it's terribly difficult for people to change tracks when an entire lifetime of thought and writing and conventions have been built up, and that's the way you have invested your life, and that's how you see the world. And yet it would entail an important invigoration, even renaissance, of criminal law scholarship were they to go back to the drawing board, as I think they really must do, and open up to these new ways of singing or seeing. Thank you.
Thank you for the excellent talk, and for, I was going to say, singing for your supper, but I see you have not got food yet. So while you contemplate that, we've got good chunk of time for some questions, and I know lots of people were keeping mental lists of things that you raised that are worthy of further exploration. So with that, Ben, do you want to start us off?
Sure.
And again, just for the taping of this, do we need a mic to be moved? There's one on either end, if you don't mind waiting to have it before speaking.
Ngaire, thank you so much. Just two questions. One that links your earlier work on fictions to inattentional blindness. And the question is how the two relate one to the other, whether or not you're suggesting in some form that inattentional blindness is actually a feature of the structure of common law reasoning, that this is something that you could isolate in this instance or in others of one of the things that lets the common law tick along in its structure, much like fictions do, but in this slightly structurally different kind of way. Could you actually generalize out of this and say we should add to our repertoire of things like fictions that the common law depends upon inattentional blindness? The second question is...
Can I jump in there so I can remember?
Yep.
Common law and fictions, does it need those fictions? Yes, I think it does, and I think it has to select out all the time, but I would always recommend that it's attentive, that it's using fictions. So if it's using a deeming, like the presumption of consent, which is the most obvious deeming, I think that the honest way out for the common lawyer, for the judge, and this is, it's a different problem for the scholar. For the judge, I think they should say, look, she's not really consenting, she's fighting, but we do have this presumption of consent. I think the honest way for the honest judge is to say, we can use this fiction, it is a legal fiction. A legal fiction tends to take the form of something whose truth we need not inquire into. It can be a conscious falsehood for a legal purpose, or it can be simply something we don't worry about the truth of it. For this purpose, it will operate in this law thus. And I think out of judicial honesty, for good judging, I think they should say, OK, we are using this fiction, and it is a legal fiction, and law can only deal at some remove from reality. In your wonderful work, you have talked about, say, mental disorder, which in law operates in a very limited fashion, but to a good end. We can't have every crazy person before the criminal justice system. So we make out that there is a much higher level of mental order in the criminal justice system. So it's a long answer, but yes, I think that selectivity and fiction is a characteristic of the common law, but I would recommend a consciousness of the fiction. Lon Fuller in Legal Fiction said, it's a working fiction in criminal law when we know it's a fiction. It ceases to be a fiction when it assumes some sort of metaphysical reality and we think it's true. We're not even doing legal work then. We think we're doing metaphysics. And your second question?
I'll just put it on the table and then give time for either.
It's a long answer.
If you have time to get to it, great. It's whether or not, in your description of the family and of the kind of criminal law-free zone, and also on the claims about the marriage not being the sort of thing, scholars making the claim, marriage isn't the sort of thing that we want the criminal law to get involved with.
Yep.
There's a real kind of symmetry between the treatment of the married wife and, albeit with different kinds of crimes and different kinds of power exertions, the child in the family.
Yes.
And a lot of those arguments are brought out similarly, and well, you wouldn't want to. This might be an evil, but you just certainly wouldn't want the criminal law to intervene in that. And I wondered if one of the outcomes of your investigation too is to put into some questioning whether other sorts of relationship of trust and dependency within the family might also have been subject to a similar sort of inattentional blindness to state-authorized violence.
I think elder abuse and child abuse have certainly been on that list. And it's also part of this pushing of regulation into other fora. So it becomes, look, this is a family matter, perhaps it's for family law, perhaps it's for marriage law, perhaps it's for church law. And we can't do everything as criminal lawyers, and it's too sticky a problem to deal with. But very good points.
Well, I see our fearless Associate Dean is distributing the mic, so we'll go in the order of wherever the mic is.
First of all, many thanks for your presentation. I enjoyed a lot. My name is Cyrus.
Hello.
On the one side, man is not a good animal. It's highly problematic. Goes to the war, nurtures, domination of not women but men also. So the over-criminalization of this animal is highly problematic. We have billions already laws around the world for us and us for laws. So in this case, we need the judge, the police, and so on to say me what's wrong and what is not wrong. And I do not know they can understand what does it mean love or not, right? So we need them to say us what's the line of rape or not line. So on the other side, this is a hypocrisy because women have legally become property of men. You know, what I see in the movies and like that, you know, is more beautiful, younger and younger. And so what we look at the woman is like property. And after that, oh, don't touch her when she doesn't like. You know, but where is the prostitution? And that's after that is taxation on prostitution. That is why you can see so rape. So it's already rape because a woman, you know, sells her body, her sexuality. So it's already a rape. Again, her dignity. And after that, you want to say it's another rape also in the frame of so-called marriage.
Look, I think it is complicated, and I'll take that as a comment, and I'll think about it. No, perhaps we can have a chat later, because I think it raises many matters. Thank you.
So I want to. So let me start by saying that I'm in complete agreement with you that the way that the law treated marital rape or rape within the family until recently was an outrage. But I want to offer you a different analysis of the development as an outsider. I'm not a criminal lawyer, but
Yeah. What are you?
I teach tort law.
Tort, okay.
Yeah. So
My sympathies.
Yeah.
Some of our best friends are torts instructors. It's a great thing to be.
I actually just today spoke with my students about the question whether we should have we should distinguish between a reasonable man and a reasonable woman, given that as I put it provocatively to my students, men are worse drivers than women because they're more involved in significantly more involved in accidents than women are. But okay, back to this. I don't see this so much as a case of blindness. In fact, you gave many examples of great attention to the issue. It's just a matter that it was analyzed differently. It was analyzed differently for various reasons. One is the historical idea that, as was mentioned here, in some respect, the marriage is, or through the marriage, the woman becomes sort of the property of the husband. But even after that, it was the idea that which, as Ben said, that there are internal limits to the criminal law, which mean that the criminal law, and perhaps law in general, should not invade into the sacred family home, and that would be very bad for, in their non-criminal law cases that say exactly that. And so, in fact, what happened when we kind of move forward is the good development, which you criticize, and the good development says no, we eliminate this. We don't accept this. What you call internal boundary. We eliminate this. We're only willing to accept the external boundary, and we're no longer saying the criminal law stops at the door of the household, and so first my claim is that it wasn't blindness, but rather kind of an intentional decision to say we're not entering there. And second is to say those criminal lawyers that you criticize for kind of eliminating this category are doing something good. They're saying we should no longer treat the family as a kind of criminal law free zone, and so you should praise them, not criticize them.
I do praise them, and they're fine people. But I then think they need to look again at their theories of responsibility. I think changing dramatically the population of people that you're looking at and the circumstances in which the behaviour occurs should intellectually require new thoughts about the actus reus, about the conduct. What sort of conduct are we trying to criminalise? What sort of relationship are we trying to criminalise? So yes, all power to them for removing the boundary. And I agree that some of it was a deliberate effort to keep the boundary there. Then it was removed. But then I think the basic work needs to be reconsidered. And what we are seeing is, good, the boundary's gone, right and proper, that's modernisation. But then everything else is hunky-dory. The core remains the same, the offence remains the same, its ingredients are not dramatically changed, and theories of responsibility can stay put too. So I think that the central theories need reanalysis, I think. But you might be right.
Could you give an example of how, I mean, maybe I kind of over-asked my question.
How would theories of responsibility, well, there's choice theories and there's character theories. You would need to look more into the nature of the relationships which we're criminalising. In fact, it's such a long thing to talk about. I think that Jennifer Nadelsky's work would actually be very appropriate here, in that you start looking very closely at the web of relationships involved. Then what's law doing with the various rights and duties? What sort of pattern are we then producing? So back to the drawing board, I think that a more relational approach would actually, and relation in a technical sense too, not just relationship, let's look at the relationships between people. The relational approach, which was advocated by Wesley Hofeld in the fundamental legal conceptions, said, let's look at the correlativity of rights and duties, powers, immunities. Let's see how they work at law. What sort of relationships have we got? So I think that there's really quite technical work that could be done as well as social work.
Bruce, I think you might be next.
Yeah. Thanks, Lauren, and thanks, Ngaire. I really enjoyed that. In addition to rethinking the theory, or I guess as part of rethinking the theory, it seems so important to me to be aware of the practices and ideologies that are hindering progress in the area. And when I think of the progress that we made, I think of the barrier to marital rape prosecution having been taken down, and certainly in Canada and elsewhere, I think reforms to other aspects of the substantive law of sexual assault. But it seems to me there's really still a huge problem proving sexual assault in any context where it's alleged to have occurred in a relationship, in private, without serious physical injuries being inflicted. Or I suppose what I should say is serious visible physical injuries. And it seems to me that explains both the absence of marital rape prosecutions, other than when there is a very serious physical assault that's visible and manifest and reported shortly after the incident. And also the difficulty of prosecuting for sexual assault in any relationship, even in a dating relationship and in private. So I'm wondering what your thoughts are on that. I think there's research that shows those barriers remain and transcend different kinds of relationships. And if that's the case, how does that inform our thinking about the theory of criminal law in this context and the work that still needs to be done?
I take your point about the evidentiary problems and the credibility problems, the lack of witnesses. And for those reasons, changing substantive law doesn't necessarily change the practice. And it's not necessarily because the law is bad or poorly analysed, though it can be. The problem with the argument from evidence, that it's so hard to get the evidence, is that you would apply that to many other areas which we would regard as far less controversial. With child abuse within the family, the problems of evidence are probably even greater. We wouldn't dream of not having them on the books or trying our darndest to get at it. So, yes, the question of prosecution and enforceability, because of the context, is there, big time. But that's not a major impediment to us in terms of putting it in our laws and trying to do something effective with it in lots of other areas. And the treatment of children is the big one. The other thing is, to stand up here with any self-respect as a criminal lawyer, I want to know that the laws that we have are good laws. At least expressively, they are sending proper messages. And those laws may never get used. I think it still matters. The alternative is simply to make rape lawful, which I think I said in another paper. Well, it would reflect the truth more. It's impossible. It's so difficult to do anything effectively with it. Should we have a society which says it's an impossible crime to do anything about, where evidence won't let us proceed, the contexts are too difficult? As Australians would say, let's call a spade, make it lawful. I had a colleague in Adelaide who wrote a wonderful paper. In it, she actually recommended that the crime became unlawful. And she was saying that de facto it is actually lawful. The successful prosecution statistics, if you take it from original report, in my jurisdiction is about 2% for ordinary rape. And with 2%, it's pretty well lawful. So what do you do with an unenforceable offence too? You could, for political reasons, say, well, it would make quite a splash if we made it completely lawful. Let's just be truthful about it. So there's problems of symbolism, what law should express. There's the evidentiary one. Does the evidentiary one stop you making it criminal or not? Yeah.
So maybe I can ask a question myself that flows from Bruce's remarks, and it goes to this issue of what you raised as the signaling of what we mark off as a criminal activity. And the problem I've been having, especially as you reach back into the historical analysis, is in a context where marriage itself was not consensual in so many contexts, and where the emotional abuse, isolation, economic oppression, all these elements can contribute so much to suffering and injustice. How do we select out this activity to mark off as criminal? In other words, leaving aside the questions that have been raised about the physical injury and the invasiveness and all the other things that, obviously do mark off criminal activity from unwelcome but non-criminal activity. In the context of the intimate relationships you're looking at, do you worry ever of creating silos, of taking an act out of the context of what might be a whole pattern of abuse that cumulatively is far worse than ever could be captured in prosecuting individual acts, and yet there isn't a language in criminal law to capture the lived experience of what that abuse might in fact cumulatively be experienced as?
They're big questions, aren't they? Well, I would actually refer you to Professor Berger's paper, not Berger, on the mental disorder offences and the extent to which they are really trying to capture reality at all, and is that a legal job? It's actually the subject matter of my book, Law's Meaning of Life, the extent to which law really is trying to reach into the deep complexity of life, which many people think, many lawyers too, many people do think that it's trying to get into the enormous richness of life as we live it. And any lawyer knows that it never does that. It's a total travesty if you thought of it that way. It's got to have a stab at it, I think. I think it's got to have some link with the complexity of society. So what does it pull out and stick into, say, criminal law? I think that given the repeated statements by the likes of John Locke, John Stuart Mill, the right to personal sovereignty, the right to bodily integrity, I think there's an expressive right which we can link to an actual form of behaviour which is suitably put into criminal law. So I think I would keep pressing for it to be put in there. What comes out in a court of law will be such a distance from the great mess of life. I think we can criminalise a punch and a rape. I think we can do that. I think they're good things to do at minimum.
Let's call it a good start.
Okay.
All right, just before we wrap up, let's hear from Professor Marilyn Pilkington. If we can get a microphone, where was it last? Danny, do you have it next week?
Thank you. I've just been reflecting on your comments in relation to an area of my interest, which is evidence law. And certainly there, I think we've seen in Canada both Parliament and the courts responding to the issues as they have changed in public perception. And it's been easier, I think, for the courts to deal with this issue in matters of defense. In the Lavallee case, for example, a woman who had been assaulted over a long period by her partner shot him in the back as he was leaving the room, killed him, and then pleaded self-defense. Yeah. And the court said, yes, the circumstances are different here, but because of spousal assault syndrome, you could see this as being acting in self-defense in the circumstances in which she found herself. Now, that's easier than using it as a sword to establish that an offense had been committed, although the offenses were assumed in that case on the basis of not very strong evidence. In the other case in Canada is the Seaboyer case where the Supreme Court was looking at Parliament's new sexual assault provisions, and which protected the complainant from being cross-examined on prior sexual history. So there are we see some real advances, even in the law of evidence, both from a parliamentary perspective and from the court's use of expert evidence to see that there are new ways of thinking about how relationships operate. Do those things give you any cause for optimism that we will
They do give me
forward?
cause for optimism, and they are examples of great imagination. Drops in the ocean, though, I think, in terms of what actually gets into court. But in terms of new ways of thinking about it, very important. So I think the symbolism and trying to examine relationships quite differently is an excellent thing to do. And I think we've just got to keep trying. Oh, no, take up basket weaving or something.
On that inspirational note, why don't we do this? I know some others are formulating further thoughts and questions, and I know that you would welcome overtures while you're here, and look forward to continuing some of the discussions started with this excellent talk, and leaves me just with the task of asking you once again to join me in thanking Ngaire for a great Genest lecture, and look forward to seeing you at the others, and look forward to the rest of your visit.
Thank you very much.